Welcome back. I'm Vince Perryman and you're watching Legalese. With us on our show is attorney Jason Nallen, and we are discussing child custody. Jason, before the break we went over the factors that the court looks at when deciding who will be the primary residential custodian of a child. And then we talked about, the three different courts that this might be heard in, whether it be juvenile court, circuit court, or chancery court. Now, at the end of that, we were talking about circuit court and chancery court having exclusive jurisdiction over anything arising out of a divorce and then any subsequent modifications of custody. So I guess it makes sense to talk about a modification of custody after an initial determination has been made. How do those work?
Well, it is substantially different. Once the court has made its initial determination, obviously there's a greater burden that the law places upon a party to go back and change that. I mean, you've had your day in court, the court's heard the proof, has applied the facts to the factors that are set out in the statute. So once that court's made that determination, the law, for I think obvious reasons, places a greater burden on you to come back and change it. So once that occurs, once there's been the initial custody determination, the court in a modification proceeding never gets to all of the factors under the best interest analysis unless the court first finds by a preponderance of the evidence, which simply means that there's a greater probability than not that there's been a material change of circumstance affecting the child's best interest. A material change of circumstance, the statute provides, does not require a showing of substantial harm to the child. A material change of circumstance for purposes of modification of a residential parenting schedule may include, but is not limited to, significant changes in the needs of the child over time, which may include changes relating to age, which is kind of a common sense factor, significant changes in the parent's living or working condition that significantly affect parenting, failure to adhere to the parenting plan. We kind of alluded to that earlier, although we were talking about it and sort of forecasting what you predict the future is going to be when we were talking about it for an initial custody determination, but obviously it can give rise as well to, as grounds for a modification. Also, the court looks at failure to adhere to the parenting plan or other circumstances making a change in the residential parenting time in the best interest of the child. So conceptually, the difference is the burden is upon the party that is attempting to modify the parenting plan or the parenting order that may be in effect, whichever the case may be, which is somewhat dependent upon whether the juvenile court made a custody determination initially or whether it was part of a divorce. Normally, in a divorce before the circuit or chancery court, the parties enter into what's called a permanent parenting plan that sets out everything pertaining to the care and custody of the child or children in fairly good detail. Although they are sometimes used in juvenile court, parenting plans are not so much part and parcel of the juvenile court procedure. But however, in either case, when you're looking to modify an initial custody award, the burden is upon the party that's attempting to modify it to first show that there's been this substantial material change of circumstance. If they fail in that, that's the end of the inquiry. They don't have a right to have the court apply the factors that determine what's in the child's best interest. However, if they satisfy their burden to show that there's been a substantial material change of circumstance, then the court, as a second part of that analysis, would go right back to the statute we just discussed. Because once there's been that substantial material change of circumstance, in the law's eyes, the two parties are essentially back on equal footing, and then it becomes a comparative fitness between the two parents again in just the same manner that we discussed. Now, some of the things that you have to think about conceptually, though, in a modification, again, there is a burden and it's more difficult. And to determine whether that burden was in essence, or whether the material change of circumstance was in essence foreseeable, and therefore it doesn't give rise to grounds to modify custody, the court looks at whether this was something that could have been conceived of and thought about at the time that the initial custody determination was made. So in essence, if a party's gripes in essence against the other parent are something that they knew about at the time the initial custody determination was made, and that could have been brought into evidence and considered by the court at that time, it may not give rise to grounds for a future modification.
So an example would be if Annie and Johnny had a little Samantha, and Samantha was an infant during the first custody determination, and it was an infant that was breastfeeding. In that situation, since it is foreseeable that there would be a time in which little Samantha would not be breastfeeding, then that wouldn't give rise to to something that could modify custody.
Correct. It's, in essence, the court would say that was something that was completely foreseeable at the time the initial custody determination was made. It can't form the basis for a material change of circumstance. Therefore, you never get to the best interest analysis. You're out of court at that.
So that's an important thing to consider if somebody's in this situation like Johnny and Annie there with little Samantha, when Annie is saying to Johnny, oh, well, let's just make a parenting plan here that's, we'll take care of this through the breastfeeding, and we'll come back and we'll revisit it. Realistically, that should be a red flag to Johnny there, because, hey, it's foreseeable, I need to deal with it now, so I need to enter into a plan that's going to, everything that's on the table is going to take care of that.
That's correct, and that's where I see people actually get into problems. I think sometimes feeling the stress of ongoing litigation or custody battle, people think, well, I'll just go ahead and settle this. I can always come back to court later if it's not working. It's not quite that simple. You may find yourself barred from coming back to court due to the knowledge that you had at that time of these potential, I guess, pitfalls or concerns that you bring up later that you actually knew about at the time you entered into the previous order. And that can effectively bar the doors of the courtroom to you.
And I think that also brings up another learning point for viewers is it's always, you got to put it all on the table for your attorney, so that way they're aware of everything you know. So that way, if you're working on a custody determination that winds up agreed to, that you've covered all those eventualities, so that way you're not barring the door to the courthouse for that substantial change.
That's exactly right. I mean, if you don't share all the information, if the client doesn't share all the information with the attorney, the client may know something that is foreseeable, but yet the attorney doesn't know to caution that client from entering into whatever arrangement they're considering, because it won't be modifiable in the future, because that information was within the contemplation and understanding of that party at the time they agreed to the custody arrangement that they're now trying to modify.
And I think, our thing in taking away from this point of the segment is that a modification is hard to get. So on the initial one, you need to make sure you take care of all the issues that you possibly can. Because if you don't, your burden is harder and the door may be closed on you.
That's correct. I mean, as a matter of fact, the Tennessee Supreme Court on this issue has said, and I'm just going to read a quote from the court, although there are no bright line rules as to whether a material change in circumstances occurred after the initial custody determination, there are several relevant considerations. Number one, whether a change has occurred after the entry of the order sought to be modified. That ties in with what we were just talking about. Was this something that was going on at the time you entered into the previous order? If so, you should have complained then, or you're not going to be heard. Second, whether a change was not known or reasonably anticipated when the order was entered. You see, that's a natural corollary to the first factor. And number three, whether a change is one that affects the child's well-being in a meaningful way. So the Supreme Court, the highest court in our state, has said, we're going to hold you to the knowledge that you have at the time you enter an order. And if you come back complaining about something that you knew about at that time, that's not going to give rise to a modification of custody.
Okay. When we return from our break, we will talk more with Jason Nallen about child custody. Please stay with us.